This is our template on a motion to withdraw. Let's say you're withdrawing. I don't know why, but some reason you are. Maybe they weren't paying you. Maybe you don't like your client anymore. Your client doesn't like you anymore. In any case, you're withdrawing. You want to do it properly. So we have a checklist here. One thing that you want to do if a new lawyer is substituting in, you want to include their contact information for the court. You are required under the law to include any upcoming settings or deadlines. So discovery deadlines, trial settings, all of that needs to be in your motion and in your order. And that's to make sure that your client is aware of what's happening of importance coming up in their case. You want to state good cause for withdrawing without harming your client. So even if you are crossways with your clients, even if your client isn't paying you, you still have a duty not to harm them in the eyes of the judge. So we usually say something like, we're not communicating effectively with the client, and that's it. And even if it's really the money, or it's really that they want to do something illegal and we won't agree and so we have to withdraw, you know, whatever the reason, you don't want to harm your client. And that's why you're withdrawing, because you can't stay in the suit and do what they want you to do, and you can't tell the court that they're trying to do all that crazy stuff either. So you just want to put something very basic. The relevant rule to look at is the text rule of civil procedure 10. Before filing, you'll want to see if the client will just agree. So if they'll agree, you could file an agreed motion, agreed order, and most judges will sign that, and that's that. But if they won't agree, you set it for hearing, and you'll want to check with opposing counsel and see if they'll agree. Then they don't have to attend the hearing. A lot of times they don't care. So then it's just your client that you're giving notice of the hearing. And you'll want to bring proof. We have a reminder to bring proof that you did give notice to your clients, because a lot of clients do not show up for this hearing. And then, assuming that you are allowed to withdraw, which typically you would be, you'll want to send that signed order to the client, to opposing counsel. Ask the client if they need a copy of their file. It is not ethical to require them to pay you to get a copy of their file. The file belongs to them, so you just want to offer it to them. You don't want to give them any reason to file a grievance or sue you, so you just want to provide it to them. And you want to send a letter that says representation is now ended. That should seem obvious because you just gave them an order on a motion to withdraw, but for the statute of limitations running, if you ever had to prove that of when your representation ended, you definitely want to have that letter in your file. So I had a case recently, in fact, where they were arguing over whether or not the lawyer gave ineffective assistance, basically, and it was post-divorce, so the divorce was over, so it would seem like his job was done, but he did kind of send some letters back and forth on a little bit of an enforcement issue. So every time you get re-involved, you should send a clarifying letter. I'm now done. I'm no longer representing you. Call me if you need me. So that's a good letter to have. So this is our template on our motion to withdraw.